All rise. The Court of Appeal in the 4th District of the State of Florida is now in session. The Honorable James A. Edwards, Chief Judge, presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. It's still morning, just barely, I guess. I've been introduced. I'm Judge Edwards. To my right is Judge Lambert. To my left is Judge Jay. We've got the one case here of Hernandez versus State, case 23-3027. We give each side 20 minutes for their argument. For the appellant, we typically reserve 5 minutes. If you want something other than that, let me know for your rebuttal. If you've got noisemakers like a telephone that's going to ring in the middle of your opponent's argument, please put it on silent because it's guaranteed that's when it's going to ring, or during one of our really good questions. So put it on silent. Otherwise, with that, we're ready to proceed.
Good morning, Your Honors. I will reserve 5 minutes, if that's okay. May I please the Court? Your Honor, I'd like to start with the second issue in this case.
Could you speak just a little louder, maybe pull the microphone closer to you, one or both?
Yes.
Thank
Sorry
you.
about that, Your Honor. I'd like to start with the second issue that we raised in this appeal, which is that Mr. Hernandez's conviction sentence must be vacated because the statute under which he was convicted is unconstitutional as applied to him. He was convicted of careless operation of a motor vehicle without a valid driver's license, resulting in serious bodily injury. He entered a plea to that. Florida prohibits undocumented aliens from obtaining driver's licenses. There's a number of states.
Was it a negotiated plea as to the amount of time?
Yes, I believe so, Your Honor.
Okay.
Florida prohibits undocumented aliens from obtaining licenses under Florida Statute 322.08. He's an undocumented alien who's resided here for 20 years. This issue was first presented to the trial court through a 3800B that our office filed. The argument argued that this was preserved by filing that 3800B.
Is it a dispositive motion? If it had been filed prior to the plea, is it a dispositive motion?
Yes, Your Honor, I believe it would be as to the
If the statute's unconstitutional, then he
Right.
wins on that.
correct, Your Honor.
I know he pled to the other count and got time served. It's not
Right.
dispositive.
Wouldn't be dispositive as to that, but it would be as to this. Your Honor, there's a case named Booker v. State, First DCA 244 Southern 3rd, 1151, 2018, which says that a constitutional challenge of as-applied nature can be raised in a 3800B.
How does Dortch apply here?
As to the prejudice,
Well, no. It says you have to move to withdraw the plea to preserve your right to appeal. You just said this would have been a dispositive. I mean, basically, this is something, if it had been raised before, he would have to preserve the right to.
yes, Your Honor, our argument as to that is that this could later be raised into 3850 if necessary to try to withdraw the plea that way. I think it
That's
also...
what Dortch kind of envisions, that any kind of complaints that you have, if you don't move to withdraw your plea, you pursue it through collateral relief.
Yes, Your Honor, but I would say that we can simultaneously raise this, or not simultaneously, rather, because jurisdiction wouldn't work, but I'd argue that you can raise this in a 3800B and on direct appeal because the statute itself that he's been convicted of is unconstitutional as applied to him.
All right, go ahead.
What evidence is there in this record that your client is an undocumented alien?
There is no direct evidence other than our allegation in the 3800B.
Isn't that the end of it?
I'm not sure what evidence exactly he could present that he's undocumented because he is undocumented.
Take your word for it.
Yeah.
I mean, no offense, but...
Yes, I understand the problem, but I'm not sure exactly how he could present that other than putting it into a sworn pleading through his counsel as we did in the 3800B. The state did not refute that. Now, I don't believe the state actually filed a response in this. The court set this for an argument on the 3800B, which ended up not being an argument. It just sort of got passed for an order. And the order denying cited a case, I believe, sorry, Your Honor. cited a case that really was just a per curiam affirmance of a similar issue where the person was convicted under the statute, but it didn't raise a constitutional claim or constitutional challenge to the statute, and there was simply a concurrence with the PCA that basically expressed sympathy for the situation, but didn't go into any of the.
That really, Judge, you're referring to Judge Altenberg's concurring opinion. Well, that's all well and good.
Right.
But that really
Yeah, it doesn't affect anything here. So
doesn't make any difference. It's actually not the holding of the court. It's just his
Yes.
observations.
Exactly, Your Honor. So my point there, though, is that the lower court here, despite this issue being presented to them, has not done any sort of analysis, has not applied strict scrutiny as we think needs to be applied here.
Is it not your client's burden to establish standing, though? And without that evidence, there's no standing?
Well, I believe we do have standing simply because this is an issue that we've raised, that he has this protected property interest in the driver's license.
But he has to be you couldn't just file it on behalf of the Florida citizens saying, I don't think this is a constitutional statute, even though I have a driver license. Your client has to say, I have proved that I'm an undocumented alien, and therefore I have been precluded from getting a license by what I believe is an unconstitutional statute. If for some reason he actually is a documented alien here, properly here, you would agree that we wouldn't have much of a discussion, right?
Correct, Your Honor.
Okay, and I think that's what Judge Jay is kind of saying, well, okay, but the first hurdle is yours. You have to show to the judge below that you are a person who is going to be directly affected by the application of this statute.
Yes, I think, Your Honor, I'd say that we've sort of made the allegation that this is so, and then at this point, it would be on the state to try to disprove this because...
No. The allegation is you have to present evidence. You can't just say, I allege this, you have to prove I'm not.
Well, we were not given an opportunity to do so because we were set for an argument, an oral argument on our 3800B. There, like I said, Your Honor, there is no evidence here. There's no evidence to prove. I mean, I guess we could present, the Social Security records or something to say that he doesn't have a Social Security. I'm not sure how you prove the absence of a fact here. But other than just
Swear him in and say, I
sworn
came
testimony.
from this country, I snuck in, I don't have any papers, I'm undocumented.
Yes, Your Honor. Well, I would suggest then that this court could remand to the trial court to set an evidentiary hearing on this matter so that we could get to the bottom of this, because our assertion is that he does have standing. This is why he hasn't applied. He couldn't apply because it would be futile to do so to get a driver's license.
Attached an affidavit to the motion, swearing to it, would that be at least evidence, at least getting a threshold?
I suppose.
I mean, we're not trying to have a law school academic discussion. I mean, you have to have standing.
Yes.
You have to show you are one of these people who have not been allowed to get a license because you're an undocumented alien. You have to show that you are one of these people who is undocumented, and therefore you haven't been able. I went to the driver's license; they wouldn't give me one because I don't have any proof that I'm lawfully allowed to be in the country.
Yes, Your Honor.
Something like that to the judge to say, okay, this is affecting you. Now let's talk about the merits of your constitutional argument, is what the trial judge would theoretically say.
Yes, I still think, Your Honor, that simply alleging it in a sworn pleading through counsel is good enough to at least entitle you to a hearing to be able to present this evidence, because we weren't given the opportunity to do so. There's no specific rule that requires that we file an affidavit
Let's
with
assume
this.
you have standing then. What's the merits of your argument?
Yes, Your Honor. That this violates substantive due process as applied to him, because
You're saying an undocumented alien has a constitutional right to have a Florida driver's license?
he has the right to travel, yes, Your Honor, and I believe that it should extend.
He has a right to travel, he doesn't have a right to drive.
Yes, Your Honor, there's a U.S. Supreme Court case, which I can find the name of here, Dixon versus Love, 431 U.S. 105, 1995, that a driver's license is a constitutionally protected property interest.
If you have one. In other words, they couldn't just wake up one day and say, all right, Edwards, J, and Lambert's license, we're revoking them for no reason, we're not going to tell you about it, have a nice day. You can't get talking about that. The U.S. Supreme Court case you're talking about,
the person had the license, and then there was an issue about how was it taken away from them without due process. I don't think that case says everybody has a constitutional right to a driver's license.
I think you do, though, have a constitutional right to be able to travel, and the necessity of living in today's society is that you have to be able to drive. I mean, this man, I believe, is married and has a wife who was, I think, now deceased, but was not able to drive herself. Someone has to be able to drive this person around, and I'd argue, though, that at this point in modern society,
Florida Supreme Court, driving is not considered a fundamental right under equal protection or due process analysis. State v. Wells, 4th DCA courts have held the right to travel does not encompass a fundamental right to drive. Isn't that case law that is kind of staring at you?
yes, Your Honor, that is the current case law. I'd argue that that's wrong, though, because
I mean, your client's not supposed to be here, right? From a legal standpoint, there's federal immigration laws. He's not complied with those, so he's here.
correct, Your Honor.
Yes, for lack of a better term, illegally.
Yes, Your Honor.
And your premise is, even if you are here illegally, Tallahassee has to let you get a driver's license.
Yes, Your Honor, because I would say to not do so necessarily goes against the purpose of the driver's license statutes and the legislative intent of creating the whole method of licensing
Isn't
people.
there a rational, it's a rational basis test for that under the equal protection that you seem to acknowledge in your brief. And isn't a rational basis saying we don't think that illegal aliens should be in Florida and we're going to rationally discourage them from coming here because we're not going to allow them to have a driver's license?
Your
How
Honor-
is that not completely rational?
Well, Your Honor, I would suggest that not having the ability to get a driver's license doesn't necessarily discourage someone from coming to Florida illegally.
I'm sure lots of everybody's coming in there. They're not coming through wherever the Texas border, wherever there's a thing going on now. They're saying, I want to get through the border so I can get to a Florida driver's license. I agree with that.
Well, I think there's like 14 states that now have a method to allow not driver's licenses per se, but driving certificates for this very purpose.
That's their choice. That's that state's choice. And our state has apparently, as you seem to concede, has not done that.
Yes, Your Honor.
Isn't that doesn't the legislature have the right to make that decision?
Your Honor, I don't think they do, because I don't think that that's a compelling enough governmental interest, this idea that if we simply don't let them have a driver's license, then somehow we're going to keep them from coming to Florida, and so that's going to solve the problem. I think that this is, I do think also that this really, we should be applying strict scrutiny here, because he, being an alien, is,
He's a suspect class?
yes, Your Honor?
An undocumented illegal alien is a suspect class that needs the highest constitutional protection under the equal protection,
Yes, Your Honor, because I think under equal protection, there's a case named Cleburne v. Cleburne Living Center, 1985 U.S. Supreme Court. Suspect classifications which require heightened judicial scrutiny are race, alienage, national origin.
How about
sex.
Filer versus Doe, 457 U.S. 202? Undocumented aliens cannot be treated as a suspect class because their presence in this country in violation of federal law is not a constitutional irrelevancy. Quote.
Your Honor,
That sounds not very good for your position, does it?
yes, Your Honor, I don't have that in front of me. I'm sorry, I don't know it off my head, but,
Well, I'll tell you about that one.
well, Your Honor, would you like me to move on to the other issue, or?
Sure.
Okay. The second argument is the court committed structural error in denying the defendant the right to delegate to his counsel of choice the decision whether to go to trial or not. Your Honor, we're making this argument under the Sixth Amendment that Mr. Hernandez had the right to choose his counsel and therefore delegate the decision of whether to plead guilty or not to that counsel.
Counsel, at 145 of the record, defense counsel, after the give and take with the judge and several recesses and so forth, Mr. Stanton comes back at record 145. After discussing the case further with my client with a Spanish interpreter from my office, he has made a determination that he wants to plead straight up to the court and ask the court to set the matter for a sentencing hearing at a later date. How is that not a waiver of your argument?
Well, Your Honor, that happened after the judge has instructed him that he has to make the decision. That's our argument, that the court has made clear that he must make the
Let me
decision.
refer you to page 154 of the record. There, the court says, so to the charge of careless operating a motor vehicle without valid driver's license resulting in serious death or serious bodily injury and an unregistered motor vehicle, how do you plead? And the person who answers that is Mr. Stanton. That's his lawyer, right?
Yes, Your Honor.
Mr. Stanton answers the question, how do you plead? No contest. The defendant says, huh? And Mr. Stanton says, no contest. And the defendant then echoes, no contest. So who entered the plea?
Well, Mr. Hernandez did, because he was told that he had to. He had to make the decision himself.
I don't understand why that's problematic to you, that a trial judge saying, okay, is that what you want to do, Mr. Defendant, because you're the one who may end up going to prison if I accept your plea. I want to hear it from you. And you're saying this is just terrible that the trial judge asked the defendant personally to tell him what he wanted to do, go to trial or to plead.
Well, Your Honor, the point we're making is that it's structural error because you have the right to the assistance of counsel and you have the right to delegate to your counsel any decision related to the case that you want to make. So for instance, when you're making the decision whether to testify or not, although the decision is ultimately up to the defendant and they could choose to testify or not to testify, if they want to let their lawyer make that decision for them, that's completely permissible, and to not let the lawyer make that decision for them would deny them their Sixth Amendment right to counsel.
Which case is it that says the lawyer gets to make the decision?
Well, I don't think there is a case directly on point here, Your Honor. I think this is an
I think
issue.
there's a case close to on point. I mean, all the cases are kind of to the opposite, and you're into your rebuttal, so I'll keep it short. But, you know, and I appreciate that this is a matter of first impression, but still. You want to save the rest of your time for rebuttal?
Yes, Your Honor.
Okay, thank you.
May it please the court? Marissa Giles on behalf of the state of Florida. Your Honors, I would like to start off by discussing preservation, which I kind of think is where you guys started as well. The state would submit that neither of these issues are properly preserved. There was nothing presented below by way of motion or objection. Nothing was reserved as a legally dispositive appealable issue. There was no motion to withdraw a plea, which is what I believe should have been done in this case. And the 3800B motion was not sufficient to preserve that first issue, which it was not raised in that 3800B motion, but it's also not sufficient to preserve that second issue as well. Because those 3800B motion is for sentencing error, as discussed in Dortch, and that's not what happened here. So moving on from preservation, I guess let's go with...
Preservation, there's no evidence that the gentleman is an undocumented alien.
Correct, right.
Standing, I mean.
Absolutely. There's definitely no standing here, and that's, I guess, should have been litigated below. That should have been a motion, a pretrial motion with evidence, and that would have established standing here, and it would have given the proper preservation for that issue. So for that issue too, we would submit that there is no standing. He has not proven that he is an illegal alien. He has not proven that he has any property interest in a driver's license. He never proved that he had a driver's license and it was taken away. So again, there's no injury in fact. It's hypothetical, it's not concrete, it's not particularized. So we would argue that there's no standing there.
What about the argument that you can raise the Constitution, as-applied constitutional challenge in a 3800B motion, and your counsel cites the case law that says that's okay to do that?
Your Honor, we would disagree with that. We believe that he would need to have filed a motion to withdraw a plea, and I believe that case, I think it was Booker v. State that he cited. That case is about sentencing, and 3800B is about sentencing. And this is not about sentencing. This is a substantive constitutional challenge to the charge that he was charged with. So we would argue that that's not a sentencing error that can be preserved through 3800B. And then moving on to the, did you have something?
I was gonna say, on the first issue, I mean, Dortch basically said there's no fundamental error exception to the preservation requirement that you have to file a motion to withdraw a plea if you want to challenge the involuntariness
of your plea that you made at trial. And Dortch, the context of Dortch was that the defendant alleged that he was incompetent at the time. And there's certainly case law that says you can't proceed and prosecute an incompetent person. And so, but the Supreme Court in the 4-3 decision basically said, well, that may, whatever that may be, that's collateral relief appeal. That's not here because that's not an exception under 9.1400 C2A, whatever letter it is. Now, is there, I don't know if it was intentional on your opponent's part, is structural error even higher up the food chain than fundamental error, that you don't have to move to withdraw if there's structural error?
I think perhaps that's what the case is, and maybe perhaps opposing counsel is getting at. We don't believe this is structural error, of course, and I believe that there's case law that says, specifically in the context of right to counsel, let me get this cite for you. I believe that it is Jackson v. State out of the Florida Supreme Court that says that it is subject to fundamental error depending on the case, because not all structural error is subject, or I guess rather, no, that's right. Not all structural error is subject to fundamental error, but in that case with right to counsel, if it's not a complete deprivation of counsel, you still have the fundamental error analysis and harmless error analysis. I mean, we have to look at the fact that this is completely harmless. I mean, there is no prejudice to the defendant here. Repeatedly in the record, defense counsel stated, this is going to be a plea. We are not going to trial. We do not need to pick a jury on this. And then...
Well, the trial judge is basically saying, hey, look, we've had 7 pre-trials, all kinds of continuances. It's the Friday before trial or Thursday. We're either pleading or going to trial. It's up to you. Get your guy in, make the decision, and off we go. I mean, if I'm over-extrapolating your opponent's argument, man, I mean, that's even a word. Basically, lawyers can show up at set hearings with the judge and say, I want to tender a plea on behalf of my client. The trial judge is there saying, well, is your client here? So, no, I've got the authority to do that. I'm going to plead, and you have to accept my plea, judge, because I have that authority. You don't need to ask the defendant whether he or she actually intends to plead no contest or guilty. That seems to be the posture we would leave it if we agreed with assuming it's even preserved under Dortch, but that would seem to be the posture we would be leaving it if we wanted to accept your opposing counsel's first issue.
Absolutely, and that's just completely contrary to all the case law that we have. Florida Supreme Court, U.S. Supreme Court, this own court.
I don't know why a trial judge would want to do that. Seems like he'd be buying himself or herself a 3850 motion.
Absolutely.
When the defendant's serving time saying, I never told my lawyer to do that.
Right. If it had been opposite, if defense counsel had been the one to enter the plea, I'm sure we would be here today on the exact opposite issue.
And there would probably be relief granted.
And there would probably be relief for him. That decision whether or not to plea is a personal decision that cannot be delegated to any other surrogate. And that, I believe, is a direct quote from Edwards, which is this court's own precedent. It's just too personal of a decision.
To me, if you're at trial and the defense attorney says, my client's not going to testify, and the defendant says, well, I want to testify, and says, I'm sorry, you let me make the call, I'm doing it, and you're not testifying, have a nice day. Seems like that would be problematic for the state as well.
Absolutely, absolutely.
Never seen that in a 3850, have we? He talked me out of doing it.
Yes, yes. Those are those fundamental decisions that the client has the right to make, and that cannot be put off to defense counsel. So
In any event, at the end of the day, the defendant pled. He opened his mouth and said, I plead no contest, just like my lawyer. I told my lawyer to do it, and I guess the argument is, well, I'm only doing it now because you wouldn't let my lawyer do the same thing I'm doing now.
Absolutely, there's no prejudice.
And therefore, I should get relief because I've been structurally deprived of my right to be prosecuted under the Constitution and other things, I guess.
Right. And I would agree with Chief Justice Edwards, too, about
Justice, buddy.
Chief Judge Edwards.
I'll take the promotion.
I'm going for the brownie points today.
You sure? It'll last till noon.
With the waiver of that as well, when we have that, issue about who actually put in the plea. Was it Mr. Stanton? Was it the appellant here? It appears that the appellant entered the plea, but clearly guided by counsel. So, a waiver, it's not preserved, we would argue that there's no merit to the point as well.
What
on
about
that issue.
undocumented aliens having a right to travel and right to driver's license in Florida? What about that?
Yes, we would argue that the undocumented
Opposed to
aliens.
that?
I am opposed to that. They do not have a right to drive, fundamental right to drive a car. They have a fundamental right to travel. All the case law cited by my opposing counsel is about moving interstate, around the state, into other states. It's not about the ability to drive a car. He has 100 other ways he can get around: an Uber, a bike, the train, a bus. It does not impede his right to travel by not having a driver's license, which he's not entitled to have. Driving is not, or a driver's license is not a fundamental right. As
Privilege, isn't it?
It's a
Case law says
privilege.
It's a privilege?
absolutely, it's a privilege, not a right, and that has been repeated in case law time and time again. So he does not have, those fundamental rights, and he's not a suspect class either. I mean, the plain language of Plyler v. Doe says that undocumented aliens do not qualify as a suspect class, so strict scrutiny doesn't apply. And so that leaves us with rational basis review. And it's pretty clear that the statutes, 322.346A, it distinguishes between anyone who does not have a driver's license. It's not a discriminatory statute. It's anyone who does not have a driver's license that commits a driving infraction that causes great bodily harm is punished under that section. So there's no discriminatory purpose behind it. It's not arbitrarily or capriciously applied, and it's rationally related to the express legislative intent of Section 322, which is the protection of public safety. So under that rational basis review, the statute's clearly constitutional.
Okey-doke.
It
Anything
appears
further?
this court has a firm grasp of these issues. Is there any other questions?
No, thank you.
Thank you. I would ask that you affirm.
Probably a good concept for us having a firm grasp of what we're here listening to.
All right. A little bit more than 4 minutes.
Yes, Your Honor. I'll be brief. Your Honor, a couple things. One, I think we're getting confused, at least as to what our argument is on ground one. It's not that he didn't enter the plea himself. Undoubtedly, he is the one that entered the plea. But this was after he was told by the court that he couldn't make this, that the lawyer could not make the decision. The court at trial court, page or 137
Is there
of the
anything in the
record.
record that suggests the plea would have been any different had the lawyer rather than the client entered it?
Your Honor, no, but we don't have to get to that point because this is structural error. He's been deprived of his counsel. So the court specifically said, Mr. Stanton, first of all, you can't make the decision for him. You can advise him, and he has to make the decision. And I'll tell him that on the record. So that's our argument, is that at that point, he's been misadvised by the court, basically, and Mr. Stanton then goes along with it, that he can't make the decision. He has to let Mr. Hernandez make the decision. So at that point, we're arguing that there's structural error because he's been deprived of his Sixth Amendment right to counsel. Your Honor, also, Your Honors, one of the things Ms. Giles said at the end there was that this was rationally related to public safety. This is switching arguments to the other point. I don't know what could possibly be the basis for there being additional public safety by not licensing illegal immigrants, because I don't know what the numbers are, but there's hundreds of thousands, if not millions, of illegal immigrants in Florida, and them driving around without insurance and without having to take driver's tests is counter to the whole statutory intent of the driver's license law in Florida. I believe that's it, Your Honor, unless there's any other questions from the panel.
Thank you very much.
I appreciate the time.
Interesting case and well argued by both sides. Thank you. We'll be in recess.
Thank you.
All rise.